If you declare bankruptcy, can you get a repo company off of it?
What?
If you declare bankruptcy, can you get a repo off of it?
Yeah, probably.
Yeah.
Oh, a repo?
Yeah, like one of my.
Just filing.
Oh yeah, because my uncles, well, they're like 80. But they bought a car for like 60 grand, and they couldn't afford it, so the dealers did everything bad. And they sold them a car they can't afford pretty much.
Okay.
And now they're losing the car, and the car's in repo. And I was like, why don't you guys declare bankruptcy and just get rid of the car, give them back the car, and then declare bankruptcy for the rest of it?
Right. I believe that as soon as you file bankruptcy, all that needs to stop.
Oh, okay.
Yeah. Like, just filing comes with like an order that stops all creditors from harassing you.
Yeah, because they're old already. They don't need credit for anything. They don't care about the car anymore. So they just want to live their life, I guess.
Yeah.
I was thinking too how much I enjoyed our class. Gosh, it saves so much time getting down to this end of the valley. I know you live down here, Victor, but it's a long drive. I mean, it took me 30 minutes to get here from Plum Desert tonight.
Well, especially with the rain, right?
Oh, my goodness. Okay. Okay, got any questions before we get started on health transfer? Yeah. How were your sausage starts, by the way?
Very good.
Uh-huh.
Very good. They're great.
I told you that was a good little
They were a big hit.
appetizer.
Yeah.
Everybody's like, oh my goodness, can I have 5 of these? Okay. Wealth transfer. We've talked an awful lot about it already. So none of this is going to come as too new to you tonight. But, okay. So we all know that right now the exemption for state taxes is $11,180,000 per person, or 11.2. We all know that California does not have death taxes. Many of us know that certain states do. For example, Washington has death taxes, Oregon has them, New York, Illinois. So not all the states have conformed to the federal law. So when the states follow federal law on taxes, they call it conformity. So not all states have conformed to the federal law for estate tax purposes. So just today, for example, I had a gentleman in my office who's been a Washingtonian for 25, 30 years, and he just learned that there's death taxes in Washington. And his estate's worth about $12 million, and he's like, so my wife just died, and you know, when I die, there's going to be taxes on the estate that's in excess of $2 million. I go, yeah, that's right. He's like, what? So he's going to become a California resident. He says, I'd rather pay a little income taxes because his income is now not as significant as it used to be. He says, I'd rather pay income taxes and not death taxes. I go, yeah, that's you're picking your poison, right? So a number of states have death taxes, and it's something to consider, and people make changes of residency based upon that. Now remember too, when you're a married couple, you can plan your estate in such a way that you have double the exemption. So if it's 11.2 and you're married, it's 22.4 million. Okay? But if you're not married, you don't have that double exemption. Okay. Everybody clear on that? So there's also the annual gift exclusion. So the annual gift exclusion is $15,000 per year per person. So if I wanted to give $15,000 to each of you out of the generosity of my heart, I can do that. And it's not, I don't have to report it as a gift, and it's certainly not income to you, okay?
$15,000 per person receiving or per person giving?
$15,000 per person. I can give $15,000 per person. So if you had 10 people give you $15,000, that's fine. If your mom and dad give you each $15,000, that's also fine.
Oh, I mean, but like you give us 30 each, 15, a total of 45,000?
Yeah, doesn't matter. I can give $15,000 per year to as many people as I want.
Did that also just go up? Because the book said
It
14.
was, it used to be 14 and now it's 15,000. In 2018, it went up to 15,000. Used to be 10,000, then it was 11, then it was 12, then it was 13, so they keep going up. So yeah, that annual gift exclusion is 15,000 per year per person. If you're a married couple, you can give 30,000 per year per person, right? Because you each have 15,000 per person. So mom and dad could give 30,000 per year to each child, and it's not considered a reportable event. Now, you also may say, well, wait a minute, mom and dads have a duty to support their children. Well, of course they do. So when you're raising kids and you're putting them through school, that's not a gift. But once your children are technically no longer dependent upon you, like they're not a student, then under the code, if mom and dad gives you, more than 30,000 per year on a split gift where they're both using their exemption, that's technically a reportable event. Now, it doesn't mean there's taxes owed. Because remember, using up the gift exclusion is like Pac-Man. If you got 11.2 million per person and you use up 10,000, now you got 11.180. So now you got 11.170. Okay, and next year, if you give $100,000 to your kid to buy a house, you would reduce the 100,000 by 15,000, which is your annual exclusion, right? And you would eat up 85,000 of your gift, of your exemption. That make sense? So when parents make significant wealth transfers, when they're transferring assets to children, you always have to look to see if a gift tax return has to be filed. Okay, everybody kind of clear on that? So you may say, well, why does any of this matter? Well, using that annual exclusion of 15,000 per year per child, and also strategically using your lifetime exemption, right? That 11.2 million is what your lifetime exemption is right now under current federal law. You can transfer significant amounts of wealth from one generation to the next generation. So let me give you an example. Let's assume that, and I've probably given you this example a number of times before, you're the number 5 employee at Google. And you got a lot of founder stock, right? Well, when you got that founder stock, because you were one of the founders, it had zero value. I think we can all agree. In the very early days of Google or Apple or any of those companies, that stock had nothing. It had no revenue. It was a dream. So I get 5 million shares of Google stock as employee number 5. And let's assume I have 5 children. Well, right now, when it's in the early stages of Google, this stock is worth 0. So if I have an appraisal on it that indicates that, let's just say the stock's worth, $1 a share. So my 5 million shares is worth $5 million. I could, for example, set up an irrevocable trust where I would put in each of my 3 boys' trusts maybe 100,000 shares each. Okay? So I've set up 3 trusts for each of you, 100,000 shares, and the value of the shares is $1 a share. Okay, everybody following my math? So because let's assume I'm not married, that would mean I made a gift to each of you of $85,000 in that year. We're all tracking that, 100,000 minus the annual exclusion of 15,000. So you're sitting here going, well, why would I do that? Well, the reason I would do that from a wealth transfer perspective is if I can gift to you, my 3 sons, 100,000 shares each of Google, then in 15 years from now, when Google was now worth, $600, $700, $100 a share, whose balance sheet is that asset on? Who owns that? Your trust. It's no longer in my estate because I made a completed gift to each of you back when the value of that stock was $1. So now each of you is sitting on $6 million of stock, and it's not on mom's balance sheet anymore. It's not included in my estate for estate tax purposes. So are we kind of clear why sometimes you're using valuations and the wealth transfer tax rules to be able to shift wealth from my estate to you Because remember, I gave you 300,000 of my 5 million shares. I still have 4.7 million shares. And now you guys are all crying in your cup of coffee because when I die, anything over and above the exemption, which is going to be like $1 billion, right? Because I have 4.7 million shares at $600 a share. What do you guys pay in taxes on? How much?
44%?
40%.
Oh, just 40?
Yeah, it's 40%. Yeah. So that's the thing. So it was smart for me to shift $6 million to each of your balance sheets using $85,000 worth of my $11.2 million exemption. 85,000 times 3, right? Because you each got a gift. So when you're doing gifts like that, they have to be considered completed gifts, because otherwise, if they're not completed gifts, they're included in your estate when you die. Okay, that makes sense. If they're gifts with strings or conditional gifts, they're not completed gifts. If it's, here, I'm going to give you this, Victor, as long as you pass the bar exam. Well, it's not a completed gift until you pass the bar exam. So that's a problem, right? Now I got a reversionary interest, remember? Still contingent. We also discussed, I know maybe a month or two ago, that the 11.2 million is only in effect until December 31, 2024, because when the tax code was reformed earlier this year, there were sunset provisions, meaning at a certain period of time, certain provisions expire. And the 11.2 million per person provision is set to expire on December 31st, 2024. And then on January 1, 2025, it goes back to the 5 million index for inflation. And the base year on that is 2011. So the 5 million index for inflation with 2011 as the base year, it's going to be about 6 million in 2025, because we got 15 years later, okay? So everybody realize, so if you've got a $10 million estate and you're on life support on December 31st of 2024, what is everybody doing? You got it. We're gonna make sure Dad dies on December 31st, 2024, because that one day is gonna make a huge difference. Remember the old tax code, you guys may not remember this, but in 2010, there was 0 death taxes.
That's what the book said.
Right.
That was the financially smart year to die.
And I had a client whose wife died in 2010. Their total estate was 80 million. She has, there was 2 trusts actually 3 trusts when she died. The survivor's trust, the exemption trust, meaning how much the exemption is, and then the Q-tip trust. Well, if the exemption was unlimited in 2010, and it was all community property, how much went into her exemption trust?
Oh.
40 million, her half. Exactly. So the exemption trust is the trust where there will be 0 estate taxes imposed. So when husband dies, when my client who's still alive dies, his children are going to inherit their mother's side of the trust with 0 death taxes ever having to be paid on. It was huge. So 40 million, had it been the old exemption, which was 5 million, if you would have taken 40 minus 5 million, there would have been 35 million. There would have been almost 13 million owed in estate taxes when Dad dies. But because she died in 2010, they have 0 owed in estate taxes. Okay? So 2010 was a good year to die. If you happen to have a lot of money. Yeah. Okay. Generation skipping transfer taxes, just so you understand. GST taxes, that's the acronym GST, generation skipping transfer. They are in conformity with the exemption. So let me explain what that means. If I set up my trust to say, upon my death, let's just assume I have $50 million. Upon my death, $50 million shall go to my grandchildren as the beneficiaries. I skipped all 3 of you boys because I was disappointed in your behavior. Okay? And I sent it all to your children. Now, a generation skip means that I sent it to a generation that's not my children, right? So you can all agree that you guys are my children, and your children would be a generation skipping. We all agree on that, right? So what the generation skipping transfer tax says is, you know what? We will allow you to skip a generation, but if you skip more than 1 generation, we're going to impose a GST tax, because here's the theory behind wealth transfer taxation, is they want to bite at the apple for every generation. So if I have $50 million and I die, we're going to pay how much in estate taxes roughly?
50 million, so 11 times 38.
We're going to have 38, so 30% of it. So let's make this easy. Let's make the math easy. Okay. I have $51 million and I die. And I leave it all to you guys. Okay? 51 million minus the 11.
Be 40.
I got 40 million. We're going to stroke a check for $16 million, right? So now the 51 million, I wish I had I guess I could write on that. Can I write on this?
Yeah.
Yeah, is that a marker right there?
Oh, yeah, I've never used this thing before. This is pretty cool.
I think a marker.
Oh, look at that. Ooh, that's cool. So 51 million minus 11 million, right? Our exemption.
Mhm.
Now our taxable estate is 40 million, right?
Mhm.
And we paid 40%. So we take 16 million. So off of that, we have 24 million. And so you guys inherited 11 million, right? Plus 24 million. Are you following that?
Mhm.
Everybody agree on the math, right? So you guys inherited 35 million divided by 3. Let's just assume that's 36. This makes my math easy. So now you each have 12 million bucks in your bucket. You agree?
Well, my kids do. I don't. You skip.
No. I sent it to
Oh,
you
you're not
guys.
skipping us yet?
I'm not skipping.
Okay. Yes.
Okay, so if I die, I have 51 million, I have my exemption, it's 40 million, we paid 40%, 16 million. So between the 2 buckets, but we're just gonna assume that's a 6, because it makes my math easy. So you each got $12 million, right? So the IRS got 16 million here. Okay, now, let's assume we went back to $5 million exemptions, right? Because now we're in 2026 and you guys are all still alive, and then you all die on the plane together. So you all die in 2026 and you all still have your $12 million. So we take off our $5 million exemption. It may be indexed for inflation, right? Okay. So you've got $7 million taxable estates, right? Do you agree?
Didn't we have a $12 million taxable estate?
No.
Oh, no, that's
you
exempt.
did, but
Okay,
you
yeah.
have- Now you
Yeah.
guys died in 2026.
That's exemption. Yeah.
And
Okay.
you have a $5 million exemption. So on $7 million, we're each now, assuming the tax code stays the same, we're paying another 2.8 million on each of your estates. You see
Mhm.
how I got there? Everybody follow me? Victor, follow?
Why is that only 5,
Because in 2026, remember, it's a sunset provision.
they're gonna
It
change?
goes back to $5 million indexed for inflation. That's how the current federal law is written. Okay? So do you see how in the first generation we paid 16 million, and in this next generation, let's just assume it's 3 million because it makes my math easy, we paid another 9 million. Are you guys following? So between the first generation and now the next generation, we paid $25 million of estate taxes. So within two generations, the 51 million was reduced by 25 million, okay? Because under the wealth transfer system, the IRS likes to say, we want to tax at every generation. We want to bite at the apple every time a generation dies.
It's excessive.
Well, of course it's excessive. Death taxes are, it's double taxation. I mean, I think it's ridiculous that we should have to pay death taxes. You paid income taxes your whole life. What you got left over is
What you've already paid tax.
what you've already paid taxes on. And yet now I get to pay taxes again if you happen to hit the mother load and be above the exemption, right? Okay, so you see how within 2 generations we've paid $25 million, right? So, everybody clear on that? Now how do I get rid of this?
Eraser,
In the middle of the screen on the bottom is an eraser thing.
and then just circle it,
Circle whatever you want.
everything.
Just complete the circle, it'll erase all of it.
And, oh my gosh, that is so cool. Wow, how much did these little babies cost? Whew. Okay, so here's what the GST tax
So we have
says.
to turn back marker.
Yeah.
Here you go. So what the GST tax says is if I've got $51 million and I want to skip my 3 boys, because I thought you guys were good for nothings and you're not going to inherit anything, and instead I'm going to give it to my, let's just assume you each have 2 kids, okay? And I'm going to go and give it to my 6 grandchildren, okay? I was not happy with your wives. I hated all of them. So I was going to penalize you all and say, nope, you're not going to get my money. And you decide you're going to give it all to the 6 kids. Oh, I should have only had 5 kids. Let's erase that. Makes my math easy. Woo, I love this. So that means that, whoop, so basically, I'm putting $10 million times 5 in each bucket, right? If you just look at the gross number.
Mhm.
Okay? But what the generation skipping transfer tax says is, I'm going to go ahead and give you this exemption from the 51 million. We'll give you the exemption of, oops. All right. Of the exemption of 11 million. Ugh, sorry, I'm new at this. Okay. So we'll go ahead and skip my good for nothing boys, but the exemption of 11 million can now apply here at this generation, but there's still going to be taxation down here potentially at the $40 million that's left over. Because the IRS says, we're not going to let you get a free extra ride by skipping a generation.
So do they tax the 40 million higher?
No, they tax it at 40%.
So you take your first 40%, or,
So they give you the exemption,
yeah,
but then you're still going to end up being taxed on the fact that you went to this generation.
so it's not an additional tax, it's still
No.
just the same tax,
It's the same
right?
tax, but we can skip that generation, so we do save. So if you pay 40 million, if you pay 40% on 40 million, that's 16 million. And do you remember under the first example,
Oh, you're
within the
right.
2 generations, we had paid 25 million. So instead, we only paid 16 million. So we saved ourselves $9 million by skipping the generation.
Yeah.
Right? So they say, we're gonna give you that, we're gonna give you some benefit, but you don't get, completely free pass, but you did save. Right?
Mhm.
We saved $9 million in my hypothetical. So it's kind of nice. So strategically, you can use the GST exemption if parents want to skip children. And sometimes parents do want to skip children. They're bad apples, or, they got enough money. If mom and dad started a business and the 3 children worked in the business, maybe the children don't need any more money and they want to pass it down to the grandchildren. So yeah, we'll go ahead and allow that. And you can sometimes save a significant amount of money overall by skipping generations. Okay? Make sense? Will?
Yep.
Make sense? Okay, because I want to make sure. Woo, I love this. Ooh,
And you know what my kids now need since I've been skipped? A brand new mansion to live in. For
A
their
brand new
health,
what?
safety, and
Oh,
welfare.
yeah.
So I'm gonna use their inheritance that is subject to their health, safety, and welfare. Having a nice, comfy mansion to live in.
Health, education, maintenance, and sport.
Yeah,
Yes.
that's what they need a mansion for.
Yeah. Well, and you know, sometimes,
I think that's a great idea, because you can even do it individually, like let's say like one person is wealthy, so they rather skip their generation,
sure,
but other people aren't, so you can work it out, you
sure you
know?
can, absolutely.
I think it's a good idea.
But if you skip more than the exemption, you're gonna get taxed on it, okay? Liability for gift and estate taxes, so it's apportioned. So the important thing unless there's language in the trust that says it's not apportioned, they are apportioned based upon who inherits. So for example, if I've got a $20 million estate and I give 10 million of it to Vincent, because he was my favorite, and I only give 5 million each to Will and Victor, because they were my second favorites. And if we have a $20 million estate, which means 9 million is taxable, which means 9 times 0.4 is 3.6 million, how much tax is Vincent paying? How much are Victor and Will paying?
More than Victor and Will.
Right, but it's apportionment. So if Vincent received 50% of the estate, Vincent's going to pay 50% of the estate taxes from his share. So why is that fair? Because look, I mean, here's the deal. If you got a 20 million, I should have been using this all along. I love
Let's take us with more debt than we get, because then we end up paying money for this.
Precisely. So if Vincent gets 10 million under the trust, and Victor gets 5 million, and Will gets 5 million, 20 minus the exemption, let's call 11 equals 9 million, times 0.4 equals 3.6. And if I were just to take the 3.6 off the 20 million, let's call it 4, right? Because it makes my math easy. And if I took the 4 off, and then I said, okay, that's 16 million, right? You all following me? And if I burden it all, well, you know what, this is not a good math example. Well, yeah, it works out the same. But here's the important thing to remember, is if Vincent gets 50% of the estate, Vincent gets 50% of the taxes.
Well, it's not a good example, because now it's just 4, 4, and 8, right?
Oh, yeah, well, that's true. Yeah, that's a good example. And then so here, 50% of the taxes is 900,000 here, right? And 900,000 here. So Vincent ends up with 8.2. Victor ends up with 4.1. Will ends up with 4.1. So it was a good example. You know why? That's why. Because here's the thing. 16 million, if we would have done 50%, we would have gotten 8 million. And you guys would have each gotten 4 million. And they would have actually been to Vincent's detriment, because you have to apportion the taxes based upon who gets what. Okay? Everything makes sense? So that's a portion. That's what's called an apportionment clause. So if spouse gets 50% of the estate and kids from the prior marriage get 50% of the estate, we don't burden the spouse with 100% of the estate taxes. We burden the spouse with her portion of it or his portion of it.
And is apportionment inferred, or does apportionment have to be written in?
Well, it's best if it's written in, but that's a very good question. And technically, under the California Probate Code, it's apportioned.
Automatically, unless you say otherwise?
Correct. So if your document is silent, the California Probate Code says you apportion it based upon who receives what. Okay? So what's the bummer about inheriting a retirement account? If you've got a taxable estate, okay, so we're over the exemption.
Because then you have to also do the income taxes too, because if it's in a retirement account, it's untaxed funds.
Correct. So here's the bummer about retirement accounts. Is they're included in your estate at the gross value, right? If you got a $10 million IRA when you die and a $10 million house and a $10 million brokerage account, your gross estate is 30 million, right? 10, 10, and 10. Are you gonna realize $10 $10 million on that IRA? No, because that IRA, over the course of time that it's spent out, you're gonna end up paying income taxes on it, probably close to 40%, right? So that $10 million IRA is really only gonna net you $6 million. And on that $10 million IRA, we're gonna pay estate taxes on 40% of it over and above, our share of the exemption, right? Because I have a $30 million trust, and I only have an $11 million exemption. So I've got 20 million, just roughly 20 million, that's subject to estate taxes. So 20 million times 40%, $8 million. If I got a third of the estate, I'm going to get a third of that $8 million. So a third of $8 million is roughly, 2.6 million, so call it 3. So my $10 million IRA, I'm going to have $3 million of estate taxes apportioned to it, and I'm going to have almost $4 million of income taxes get apportioned to it over the life of the draw, the RMDs. So my $10 million IRA is like $3 million. Yeah.
Is that why it's better to get a Roth IRA where it's like your income taxes up front?
That's
It's not
right.
taxable up front.
That's right. That's why my 401k is a Roth 401k.
It's better to bury your money in the backyard.
Yeah.
Well, just buy gold and
Well,
bury it.
that's exactly what my mind.
Listen,
I was gonna say it.
I have a client, he was an accountant, CPA, and all he did all those years, I mean, he had money on the books, but he accumulated gold. He went and bought gold coins. And I didn't sign his estate tax return, but and I wouldn't have. But yeah, that gold was
1,200 an ounce right now or something.
transferred without anybody knowing it,
Yeah, there's no
except for the 5 kids that knew the safe.
record. That's what my
I
uncle
spent
Victor
it.
did.
I spent it on what?
Right.
Well, on gold, but no one knows that.
Yeah.
I spent it at the movie theater,
Like I said, buried in the backyard.
Yeah. Well, and that's
Just
why
make sure you tell
sometimes-
someone where it's buried.
Right.
That's why sometimes people do, precious metals and diamonds. I mean, diamonds have appreciated substantially, especially large diamonds. There's a lot of alternative investments that people hold, But yeah, so sometimes, people do those types of things. I just tell people, don't tell me about it. Because, right, if I'm signing the estate tax return and that people have that, I can't sign that return.
You're further into
Because
fraud.
remember, prepare a liability.
Yeah.
It's like that law firm in LA, when Michael Jackson died, they prepared the estate tax return and they valued the interest of his, posthumous, image, at $1 million on the estate tax returns, and they've already monetized the Michael Jackson estate for $1 billion.
So it's like $1 million only for his.
Oh yeah, so of course it's being audited.
Yeah.
And I mean, I was listening to the gentleman who was the law firm that represented the trustees, and I don't know what the outcome has been yet because I don't think the tax court has decided, but I would be very worried if I was those guys and I prepared that return because I think they might have prepared a liability. And it's quite substantial.
Well, yeah. I mean,
Yeah.
if you
Oh, yeah,
only
because-
value Michael Jackson's likeness at $1
At $1
million,
million. But the reason they did that is
Screw
because they
himself.
didn't want to pay estate
taxes.
taxes, right?
because I'm sure Michael Jackson had no money to spare.
Well, he was not doing well late in life. I mean, he had all those lawsuits he defended. I mean, he had kind of imploded just from an image
Big
perspective.
nuts.
So, but then after he died, they certainly monetized that estate quite well, and they did that. They did that whole video and all that kind of stuff. They made a ton of money off of him. Okay. So if an asset is in joint tenancy, and so let's just assume I die and I have $1 million in joint tenancy accounts with each of you, and then I have everything else in my trust. And between the joint tenancy accounts with my 3 boys and everything else in my trust, we've got $20 million. Are your joint tenancy accounts gonna be burdened with a share of the estate taxes?
I don't think so. They transfer over and so.
No, it still is burdened because it's still part of your estate, regardless of whether it goes through joint tenancy, beneficiary designation, life insurance that was in your estate and goes to your beneficiaries. The apportionment happens across the whole estate.
So even though it's not subject to probate,
Correct.
it's still subject to taxes.
Correct. Yeah,
Okay.
exactly. And that's a very good distinction. Because remember, when people die, you can have some probate assets, you can have beneficiary designated assets, you could have assets in trust. You can have assets in all different categories.
Is the community property,
Is it the same with this?
subject to taxes?
The half that belongs to the decedent is,
Okay.
yep, absolutely. So you could have those community property assets with wife number 3. You can have insurance proceeds that aren't in an irrevocable insurance trust that go to my 3 boys, $1 million each. You can have other monies that go to the grandchildren in the trust that everybody's gonna get their apportionment of estate taxes.
Seems so why don't you just have the estate pay it and then
Because how is that fair if your money came through a joint tenancy? Then let's just assume you got your money, your $1 million in each of your joint tenancy accounts, and let's assume that my grandchildren were the beneficiaries of the trust, because again, I wanted you guys each to have your $1 million and that was it. Well, then the grandchildren are bearing 100% burden of the estate tax and not all the beneficiaries. Now, if my trust says, upon my death, all of my estate taxes shall be paid from my trust, and then the residue, then your joint tenancy money is free and clear, right? But it just depends upon the tax apportionment clause, and to Vincent's question earlier, if there is no clause, the California Probate Code assumes apportionment based upon a pro rata amount of what you receive from the estate, okay? Okay. So that's why you have to look at the total estate.
There's no way to pay that up front, like so you don't burden your kids with it.
No, and that's why, when you have a taxable estate, the trustee, if there's a trust, make sure it's paid, because that's the trustee's obligation, right? Their fiduciary duty is to make sure taxes are paid, income taxes and estate taxes. So trustees, if there's taxes that are owed, they're not necessarily distributing all the estate. Their taxes are owed at 9-month mark, right? The tax return, you can get 1 6-month extension, but the taxes are owed within 9 months of date of death. So the trustee is going to make darn sure they're remitting those taxes, because otherwise the trustee is on the hook. So I had a gentleman who's a trustee, and he wrote me an email the other day. He goes, Julia, it's been 2 years now since my sister died. Can't we distribute the last, $100,000 that's in the trust account? I said, Dear Tom, good to hear from you. It's amazing it's been 2 years. However, remember that we didn't file the estate tax return until just around the 15-month mark. Okay, so she died October 31st of 2016. We filed the estate tax return, I was counting fingers, November, December, January, February, March, April, May, June, July, plus 6, August, September, October, November, December. We filed the estate tax return in December of 17, so it's really only been a year, and the statute of limitations on a estate tax return is 3 years. Just on any income tax return, unless it's a fraudulent misstatement, then there is no statute. But if, once you file your income tax or estate tax or gift tax return, it's a 3-year statute of limitations. Now, the IRS used to have what you called an early closing letter, where you could send a letter along with the estate tax return saying, we request that you give us an early closing letter so that we can cut off the statute of limitations sooner. They don't do that anymore. So you got a 3-year statute, no matter what way you cut it. So I told my trustee, I'd love to be able to say, go ahead, but her estate was right on the cusp. Her gross estate was over the exemption amount, but her net estate, after we deducted some expenses, was just below the exemption. So since I know that we're right at that cusp, and basically 100% of all estate tax returns get audited, it's not like, 0.001%, it's almost 100% get audited because there's so few estate tax returns filed. I told my guy, no, you can't distribute it because if the IRS comes back and challenges anything, are you gonna get money back from the beneficiaries? Well, hell no. Beneficiaries, once they have their money, you don't get it back. It's pretty hard to say, oh gosh, we're sorry. There's death taxes owed. Now please give us back some of the money that they probably already spent, right? I think we can all agree that if you're a good fiduciary and you have estate taxes that are owed or you're right on the cusp, you are not distributing until you know you've cleared the statute of limitations on that tax return. So he's just gonna have to sit on the money for another, basically 2 years.
It's done.
It is dumb, but that's the rules.
Yeah.
Right? So, since we gotta tell our clients what to do, we have to say, no, you can't give the money out. Now, if it was to just him and his 2 siblings and they were all responsible and would sign an agreement that said, hey, we'll hold on to this money and if estate taxes are owed, we'll give it back, that's fine. But a lot of these beneficiaries, there were, I think, 20-some beneficiaries, and there are a lot of nieces and nephews. Oh, that money's long since spent. Lifetime of accumulation is probably all gone. Okay. Okay, and we talked early in the semester life insurance. Life insurance is included in the estate for estate tax purposes unless, anybody know the answer?
What was the question?
Life insurance is included in the estate of the decedent unless
they goes into a trust.
Unless it's an irrevocable life insurance trust, right? Irrevocable life insurance trust or an ILIT, I-L-I-T, all caps. There's a way that you can hold life insurance, and that money, when it pays out, will not be included in the estate for estate tax purposes. Okay? So if you have an uber wealthy person and they have life insurance, typically you have that in an ILIT, so that when it pays upon the death of mom or dad or the second to die, if it's a joint policy, that money that comes in is not taxable for estate tax purposes. Okay?
Why not? Just because they say it isn't?
Because you see, so let me tell you how an ILIT works. Let's say I'm super wealthy and I have a $20 million life insurance policy. When I take out the policy, the owner of the policy is the Julia Burt Irrevocable Life Insurance Trust. I name you, Vincent, as my trustee because you were the one that paid attention the most on ILITs in law school. So you are the trustee of the trust. I gift to each of you $15,000 per year, right? I can do that under the annual gift exclusion. But instead of giving it to each of you, I gave it to Vincent to put into the checking account that Vincent set up for the ILIT. And under the Internal Revenue Code, I've made a gift to which you have an interest. Now there's this case, an old case that was called the Crummy. It was the Crummy family, C-R-U-M-M-E-Y. So Vincent, as trustee of my ILITs, issues what's called a Crummy letter to all of his brothers that says, Dear Will and Victor, Mom made a gift to the trust, $15,000. You have the right to request the distribution of that. And if you don't, your power to withdraw, your withdrawal powers, expires in 30 days. So of course, since you guys were all good students, you don't withdraw your gift and you let it stay in the ILIT that Vincent is the trustee. Then Vincent turns around and pays the annual insurance premium of $45,000, right?
Sure.
Yeah, because that's what you do, because you've been told to do that. Because the insurance premium is $45,000 a year, and I just happen to gift you $45,000 in which to pay that premium. If I observe all of those formalities year after year after year, when I die, and that $20 million of life insurance pays out to each of you, 1/3, 1/3, 1/3. That is not a taxable gift, and it is not included in my estate for state tax purposes. So you all walked away with $7 million of life insurance proceeds. Because mommy was smart and I gave you gifts and you didn't take them out and instead you bought insurance. Perfectly legitimate. People do it all the time.
So is it not subject to the death, like the estate taxes?
Nope.
Because
I had no incidents of ownership.
yeah, you don't own it. The weird trust does it. You directed me to set
You
up,
guys are the owners of that trust.
and then so it's basically our life insurance policy on your life
Right.
that we're paying with gifts that you give us.
Exactly.
That's just complicated.
But it's brilliant.
No, it is, but
But people do it all the time.
Well, it has to be that way, right? Because I think you can cash out your life insurance policy.
Because if you have incidents of ownership, then you own it and then it's included in your
Your
estate
estate.
for state tax purposes. But because you guys own the policy, you just happen to insure me. Okay, you took that money I gave you and you decided to buy insurance on my life. You own it. It's in your estate, not mine. It's not taxable and it's not included in my estate for death tax purposes.
I didn't know you could get life insurance from someone else.
Sure you can. You usually have to have an insurable interest. I mean, so usually it's relatives.
Oh, okay.
So it's not like you could go out and say, you know what, I want to buy life insurance on Julia.
Yeah, just
Can't do
because you're
that.
gonna wait.
Yeah, I was like, who do I think is gonna die soon?
Yeah.
I'm like a $2 million policy on that person, please.
Walk around the
So
house
by
and
the fact-
something.
Putting aside the fact that they probably wouldn't qualify, you do have to have an insurable interest. And insurance companies, you know, when you get larger policies, they want to know that it's for a reason, right? So, for example, you know, my husband has I think he has $2 million of life insurance, but I have $4 million of life insurance. And for them to write a larger policy, you know, they ask us a lot of questions like, well, why do you need $4 million of life insurance? Right? Because they don't want to think that, you know, I mean, insurance has to be somewhat proportional to what you're trying to insure.
Mhm.
So if my husband said, no, we just want a $20 million policy on Julia, he may say, well, what is it going to kill her? Right? There's no reason that we need a $20 million policy on us. It's not like we owe death taxes for $20 million.
So would you have to owe like $20 million for a house or something?
Yeah, if you had a huge estate and you had taxes that would be owed, then there would be a reason to justify. So when I got my second $2 million of life insurance policy, they asked us a lot of questions to make sure that it was a valid reason for having now a total of $4 million of life insurance, right? They definitely screen that stuff.
And if someone owes the money, he said it's probably be a higher premium or higher.
Right, and plus they were writing a 20-year term certain policy. I wanted, you know, I took out another policy when I was 50, so it will be in effect till I'm 70, and it's a flat rate. I didn't want it going up every year, so, you know, they look at it like, well, why are they pulling out another $2 million of life insurance? And of course, you know, they scrutinize your health like crazy. So, and this was, I don't know this, but I've been a cancer survivor now for 14 years, so I was beyond my 10-year mark of cancer, so they were willing to write me, but they put you through the ringer, you know? So they want to know, like, why do you want another $2 million, you know? So it's just all about risk assessment, right? Because, you know, I don't plan on dying, but is it conceivable between 50 and 70 I might die? Well, yeah, probably possible. And I pay about $5,000 a year, so, you know, it's not a bad investment if I die in the next 20 years, but if I live till 71, it's a shit investment, right? Because nobody got anything. Paid $100,000 for nothing. But that's insurance, right? Make sense? So that's how I live.
So your life insurance only covers you for a certain amount of time?
Depends upon policy.
Then is it just gone?
That's actually
That's not how my life insurance works, so I never knew that.
But some policies are for life, but a lot of policies are for a term certain.
That's actually smart though, because if you're over 70, you probably need long-term care insurance.
And when I'm over 70, I don't need life insurance anymore, because life insurance is basically, if I die, Because
Cover your
at this
debts
point in my
and all
life,
that.
I'm the main breadwinner in my family. My husband's 9 years older than me, and he still makes money, but not like I do. And so since I'm the main breadwinner, if I die, I don't want him kind of up the creek with no paddle, because all of a sudden, poof, my income's gone, right?
Yeah.
So it allows him to make sure the mortgage is paid off and live happily ever after. He just better not marry some bimbo.
That turned into the finger.
No bimbos, that's what I said.
Nice, respectable young lady, but no bimbo.
No bimbos. Okay, family limited partnerships. It's on page 950 of the book. Let me just explain what a family limited partnership or FLIP. Okay, that's an acronym, FLP. Okay, a lot of families have a bunch of real estate, right? Mom or dad was a developer, and then they bought this little mall, and then they bought this next shopping strip mall, and then they bought this partnership, and all of a sudden, when they're 70 years old or 60 years old, they own like 10 different, retail centers and 5 different, Carl's Juniors, and, they just amass real estate. So how a FLIP works is this. Mom and dad form an entity. It's basically a general partnership. Mom and dad, or mom or dad, is generally the general partner, the GP. So there's a 1% general partnership interest, and then there's a 99% limited partnership interest, LP interest, right? So between the 99 and the 1, it adds up to 100, agreed? The general partner basically has superpowers. They pretty much run the partnership. They pretty much decide what the distributions are. They pretty much run everything there is to run, and they get to decide everything because they're the general partner. But mom and dad want to start to gift assets to the kids because we're trying to reduce the estate, and we're trying to get the kids kind of familiar with the business and shift income, because if you own 100% of the business, you get 100% of the income. But if you've managed to shift some assets down to other generations, you no longer have 100% of the income. So again, it's another form of wealth transfer. So we set up a FLIP. We transfer assets. Primarily, we do real estate. People used to do stocks and equities and bonds, but that's a little sketchy now under the current IRS rules. So we usually transfer real estate into the FLIP. We get an appraisal. So you have to appraise all these properties to figure out what this FLIP is worth. And then over time, mom and dad start to gift interest in the FLIP. So in year 1, I may give you each 1% limited partnership interest. Now you each own 1%. I'm the general partner, I own 1%. And then there's 96 other limited partnership interests that I own, right? Everybody following the math? Because I have 1 plus 96 and you each have 1. And depending upon what the appraisal value is, it may or may not be above the annual exemption, the $15,000. So I may be eating away at part of my lifetime gifting, and I may not be. It just depends upon the value. But here's the beauty of a FLIP, and this is why people like them. When I do not own 100% interest anymore, I no longer have a fee simple interest, right? You remember that from property law, right? So if I don't own 100% fee simple interest, under the Internal Revenue Code, I am allowed to take what's called a fractional ownership discount. Because now I no longer own 100%, which is the purest form of ownership, right? I have fractionalized my interest because now my 3 boys each own 1%. So if my FLIP at my date of death, if we appraise the underlying assets, and the underlying assets are, let's just say hypothetically, worth $10 million. And by the time I die, I've gifted over the years to you each, let's just say 10% each. So now I have 70% and you each have 10, right? It's worth $10 million. What does your intuition tell you my interest is worth at death? 7, right? Because 10 million times 70%. But the nice thing about fractional ownership discount is there's lots of case law on this. It says, because I no longer owned a perfect, pure, 100% fee simple interest, we get an appraisal that discounts what it's worth. And a typical fractional ownership discount is almost 20% under the code. So my 70% or my 7 million with another 20% whacked off of it, I just took that interest from 7 million to 5.6 million. I saved that 20% in valuation. And the nice thing about that is if you have a very wealthy person that we're going to have estate taxes, we can get significant discounts on the estate, okay? That's how a family limited partnership works. I think with my clients, I think I have probably 10 different clients that have flips, within their estate. Not everything is in the flip. They still have their houses and their brokerage accounts. But a lot of times it works so well with real estate. Okay? Make sense? Questions on flips? Going once, going twice, gone. Okay, we talked about powers of appointment, page 955. Everybody realizes if you have a general power of appointment, it is included in your estate for estate tax purposes, right?
Mm-hmm.
Perfect. Okay, marital deduction. I'm married. I have $100 million estate. I leave 50 million of it to my husband, and I leave the other 50 million to each of you to be split, right? And it's an outright distribution to my husband. So it's his money because he has kids from a prior marriage, right? And then I left the other 50 million to you as my 3 boys. How much is my taxable estate?
How much were the monies?
100 million estate. I give 50 million to my husband, and I give 50 million. I give 50% to my husband and 50% to my 3 boys. So 50 million each. You guys are splitting 50 million, right? So how much is my taxable estate?
Taxable estate would be the 100 million minus the 11.2, right?
Minus.
And your husband would be able to deduct his 50 million,
right?
And wouldn't be taxed on it.
Correct. Because that's the marital deduction.
Wouldn't we still get taxed? Wouldn't we get taxes taken out of our 50 million for the 100 million minus the 11.2?
No. So here's how you do the math. But you're close.
Can't do math. I went to law school.
That's why I always say if you're good at math, you're really good at states and trust attorney.
It would be
Okay,
40
so-
million, we get taxed on the 40 million.
So I got $100 million estate,
That would be
and
fair,
I give
but-
to my husband 50 million, and I give to my 3 boys the other 50 million. So what is that? 13, 16.6 million each, right?
Yeah.
So here's how the marital deduction works. 100 million, take off 50. It's not taxable it'll be taxable at his death, but it's an absolute 100% reduction for anything that goes to a spouse. So now it's 50 million minus the 11,
Oh, okay.
39 times 40%, so roughly 16 million.
That's how I was hoping it was going to come out, but knowing the federal government.
But
No, that's why it's called the unlimited marital deduction.
But it has to be like the half. It can't be.
It can be whatever.
It can be really.
If this was all my separate property, that 100 million was all mine.
But I can give the husband
70 million.
and it's all still tax free.
Yeah, when he dies, there's gonna be a tax imposed.
And it's not a community property idea. It's just like
No, and this was, let's assume that was my separate property. I was, Julia Getty. It was my money. I never shared it. I never put his name on it. I never commingled it. I never transmuted it. It was all mine. Okay, so if I leave husband, spouse, that was the big Windsor case, right? That's how gay marriages were ruled on by the Supreme Court. Because we had our gay couple, the 2 women in New York.
Okay.
Remember, they had been together for decades. The first one dies, leaves everything to her partner of 30, 40 years. It was a taxable estate. Her partner had to pay $2 or $3 million of estate taxes. And had they been able to marry, they would have had zero because the spouse would have qualified for the unlimited marital deduction. So they challenged it, brought it all the way up to the Supreme Court, and the Supreme Court said, you're right. It was an estate tax issue that determined the same gender marriage at the Supreme Court.
Mhm.
Okay, because it wasn't fair. Because they couldn't marry, they ended up owing all these other taxes. Okay, so that's why the unlimited marital deduction is so important. You can give as much as you want to spouses, back and forth, back and forth.
Okay, but a practical question.
Yeah?
How do the children, say you have a split family type situation say even better, you have the family who they don't even know who the heirs are and they have to go find them, but dead uncle or whatever got a $50 million inheritance from his now dead wife. So that $50 million that he got from his wife would technically have to be claimed in his estate taxes
When he dies.
When he dies.
Sure.
But say you're estranged, how does that work? Like, what if you don't know that you got a $50 million inheritance from your wife? How do you know
How would
that?
you not know?
Well, if you're estranged, so you don't know your uncle, but you're the last living relative, and they find you in East Bum, wherever, Maine. So
I guess I'm not following my fact pattern. Help me out here.
okay, so
Or your fact pattern.
husband and wife are married.
Okay.
Wife dies, gives the $50 million to her husband,
Okay.
obviously tax free.
Correct.
There's no other family other than an estranged, doesn't talk to anybody in the family relative that an airship company finds in the middle of nowhere.
Well, why do we have to find any airship company if I left it all with my husband?
Well, no, I'm saying your husband's dead now. So you've already
Okay,
died. You've
okay.
left your 50%,
Okay.
your $50 million to your husband.
Correct. Okay.
Your husband now dies.
He dies intestate.
Yep, and the
Okay.
only known person is some relative he didn't even know about in the middle of nowhere.
Well, they hit the mother load.
But how do they claim that $50 million inheritance on an inheritance?
They don't know about?
Yeah, if they don't know about
Because
it.
what would happen is whoever is in charge of administering the dead husband's estate would hire an heir search company, or the public guardian basically would petition to probate this person's estate, and then they would hire the heirship company.
So, but does the IRS keep records on like when a married couple claims a marital deduction as far as like an inheritance goes?
If there's an estate tax return filed, yeah.
So then
Because on
they
the
keep
estate
track
tax
of it?
return, yeah, because what happens on the estate tax return, you have to say who the beneficiaries are, and you have to give their name and social security number.
Okay, and so then when the husband's estate
When he
tax
dies,
goes up, they do like some kind of a search that says,
Oh,
he
yeah,
received
because
50 million
when
from
he-
this person in this year, and
Right, when he died, there's gonna be an estate tax return done, and they're gonna say, one of the questions on the estate tax return is, were you previously married? If so, what is their name and social security number? Oh,
okay,
yeah. Yeah, the IRS connects that. Like I
Okay.
said, 100% of the state tax returns are almost audited.
okay.
Because there's so few filed. I think the number last year, I heard it recently, I think last year there were like only 7,000 estate tax returns that were filed.
I don't get why there's a 3-year statute of limitations then. They should be able to get that done in
You'd
A
think,
year.
yeah, but I think it's a relatively small group because the people that are auditing estate tax returns, there are a lot of lawyers in that group.
Oh.
Yeah, because, there's a lot of people that do pretty tricky things.
Yeah.
Right?
And it's usually probably an attorney that's telling them, hey, file it this way.
Like the Michael Jackson
Yeah.
estate. Hello? You
So
don't
they're trying to find those loopholes and,
You bet, because on the Michael Jackson, I think the preliminary assessment for additional estate taxes was in the hundreds of millions of dollars. Because they said, look, you've already monetized within 18 months. Because remember, those trustees came out, and remember after Michael Jackson died, all the things that were happening, there was that production show, everything.
Yeah.
They were monetizing his image so fast. Whereas what's been interesting, have you noticed how quiet the Prince estate has been?
Yeah.
Right? Since Prince died, they've hardly monetized anything in his estate. And you know why?
Because they don't pay taxes on it.
Because they're not wanting to, they're wanting to just stay below the radar. They're taking lessons from the Michael Jackson estate. They're going, okay, remember how they talked to you about all the albums and records that they have for Prince that haven't even been released yet? Well, how the hell do you value those?
Yeah.
Right? I mean, it's so difficult. So I think what the Prince estate attorneys have said is, okay, we see what happened in the Michael Jackson estate. We are not going to monetize right now. We are going to lay low. We're going to get the smallest valuations possible. I mean, I'm surmising here, so I have no inside knowledge, but if I was advising them, I'd go, no. We're going to get the lowest numbers possible. We're going to file the estate tax return. You're going to pay the estate taxes, and you're going to lay low for 3 years, and you're going to let that statute run. And even though it might hurt you to not monetize it right away, you're going to monetize it starting in 4 years from now.
Right. But that way the government can't prove their case that you like, what? Like,
There's nothing wrong with that.
Well,
There's nothing wrong with that.
yeah, I know. It's a great idea because if you went and sold one of those and let's say, like, some company bought it for $10 million or what, now there's 100 of these things and now it's like, $1 billion.
Yeah.
You know what I
And
mean?
now you got to pay
And now you got
20% on
problems.
$1 billion.
Now you got problems. Yeah.
But you also don't see that as like a fraud issue because you're intentionally not
Well,
monetizing.
and that's why I think you have to be very careful because there's no rule that says you have to monetize the imagery. There's no rule. And remember too, there was also some dispute about who the heirs are. Remember there were a couple like kids that came out saying, oh yeah, I had sex with Michael Jackson and then we made baby. We made love babies. There are a lot of issues in that estate, especially because he died intestate.
Michael Jackson did?
No, Prince.
Oh, Prince.
Really?
I didn't think I thought he died with a will. I thought it was Aretha that died intestate.
No, I'm pretty sure Prince died intestate.
Oh, but I think Aretha Franklin
Aretha did
too.
too.
Yeah.
No trust. I mean, what do these people think?
But they're never going to die.
They don't care.
it's just
Yeah, they also probably don't care. I have enough money, and if they want to fight over it when I die, I'm dead. I don't care.
But now their business is public record too.
Yeah.
They're dead.
Yeah, but their kid. I mean, it's so irresponsible.
Yeah. You're right.
It's just downright irresponsible.
Oh, it is. But
But yeah,
dead people don't care.
they don't. I always say it kind of ends your to-do list.
Yeah.
Whatever you
You've
do,
reached the end.
better. So, and I always also joke that there's no U-Haul behind the hearse. So don't get to take it with you. All right.
I want to get buried with my gold.
What?
I want to get buried with my gold.
Build a pyramid for you too.
Yes, I want a pyramid.
The Vikings did the same thing, right?
Oh,
We'll do one out in like the wash.
Yes.
You'll still be in the desert, and it'll flood like once you're just like the Nile.
I want my entire state converted to gold and buried with it.
well, remember there was this lady too in Europe last year. I think it was last year or the year before. She hated her family just horrifically because this was written up. I forget where I read it. So she knew she was dying, so she shredded all of her money.
Oh,
Oh
wow.
my god.
She just like turned all the cash and shredded it.
Shredded all of it.
Wow.
You can still send the pieces to the reserve.
You can still send the pieces to the reserve.
I
Mutilated money refund, yeah, but
yeah, she shredded all of it.
It's gonna be years before they return your check. Because
they have to put it all back together.
That's right. Okay, qualified domestic trusts. Let me explain what QDOTS. It's on page 969. But qualified domestic trust acronym is QDOT. Apostrophe S, all capitalized. QDOTS. QDOTS. If you are married to a non-U.S. citizen, you cannot do an outright distribution using the unlimited marital deduction we just talked about. Because the IRS assumes that your non-U.S. spouse is going to take that money and skip back to whatever country they came from.
Damn straight.
Right? So if I was talking to a gentleman today, he's Chinese by birth, he is a U.S. citizen, his wife is Chinese, between the two of them, they have about $20 million in assets. And I said, this is great. I mean, we can plan, but the problem is for your wife, if you die first, because he's 10 years older than his wife, I said, if you die first, I can't just leave this to your wife. Your wife is not a U.S. citizen. She cannot be trustee of this trust. You have to set up a qualified domestic trust with a U.S. trustee that can take care of your wife, but it cannot be an unlimited marital deduction, outright gift to a non-U.S. citizen spouse, okay? So if you get presented, if you're doing estate planning and someone walks in and says, that's why on one of my questions on my intake is, are you citizenship, right? People are like, why do you care about citizenship? Listen, I'm not judging, I don't care. Are you here legally or really, that's not my question. But if you're a U.S. citizen and you're married to someone from Mexico and they're not here legally, I can't just draft a trust that says, you know, here, this is how it's gonna go. I mean, that's malpractice, right? I think we can all agree on that. So sometimes people are thinking I'm like making a political statement. I'm not making a political statement, I'm just trying to plan your estate plan. So do whatever you want, but that's the problem. So QDOTs are pretty darn necessary when you have non-US citizens.
But so can you do like unlimited gifts during your lifetime to your spouse
Nope.
so they can hide it offshore at least?
Nope.
Oh.
The annual gift exclusion to spouses is limited, and I can't remember the exact amount. But I think it's $65,000, something like that.
Oh, so it's at least better than the gift.
Yeah, that is limited.
Oh.
Okay.
So, I'm sorry, can you say that again? So, I understand the problem, but what does the QDOT do?
So it's a way to hold the money in trust. So if I have $10 million and I want to leave $10 million to my husband Randall, who happens to be Canadian, I can leave it in trust for him, and he can live high on the hog for the rest of his life, but he can't control the money. He can't be trustee of that QDOT because he's not a U.S. citizen. So it's going to have to be you, Will, as his trustee. So he's going to have to say, well, I need money, you know. Because again, what the IRS assumes is Randall's going to go, you know what, my wife is dead, I'm going back to Canada, I'm taking the money with me. Okay? And they're pretty much right.
Is there like limiting instructions for the trustee? You can just be like, let him have what he wants.
Well, yeah, that's pretty generous, but what he can't do is he can't just take it all back to Canada because the IRS is saying, we might want to bite at that apple at the second to die. We might have death taxes, right? Because if I got $100 million and give it all to Randall, and then Randall takes all that money to Canada, they never got their bite at the apple, did they?
So can Randall ask the
Just you give him $10 million a year and
for gold
No.
and then just take the gold?
No, that's a breach of the fiduciary duty, right?
I live a very rich lifestyle. You don't know my lifestyle up in Canada.
I don't think you want to be defending that to the IRS, right?
I'm Canadian. I don't care what they say.
Are you Canadian?
No. I'm just saying if I was Canadian, I wouldn't care what the IRS is saying.
Except that we do have tax extradition treaties, so.
Oh, yeah.
So
Right?
what was it? You gotta do it.
Canada just won't give you up if you're getting the death penalty.
Right.
Costa Rica's where Drucker says that she got for.
Yeah, Costa Rica.
Yeah, they have pretty lax laws, except now you get abducted by the, guy that lives in the house next to the Airbnb and he kills you.
That's like this was.
Not if I have my $100 million inheritance, I'm not going to be living next to the guy.
Right. But that's the scary thing. Okay, let's also talk about portability of exemption, because this is an important concept. Under the current federal law, and this has been the law since 2011, we all know we each have an $11.2 million exemption for estate tax purposes. Under the current law, you can capture what's called the DSUE, another acronym, all capital DSUE, stands for the Deceased Spouses Unused Exemption. So what that means in English, and this is talked about on page 970, is that if I am married and my husband dies, and he has the type of trust, which we do, that says, honey, I love you, I give you everything. Now, all of our money is on my side of the ledger, right? We all agree that's a honey, I love you, give you everything trust. But I don't need to file an estate tax return because our estate tax exemption, we were below my husband's share of the estate was below 11.2 million, but I have an $11.2 million exemption because he died this year. I can port that exemption and save it for my death. That's called portability of exemption. And I port that exemption by filing an estate tax return at the death of the first to die. I inform the IRS, here's my husband's interest in the estate. I'm now porting the rest of this interest until my death. And it's a way to increase my exemption at the death of the second to die. Which means a married couple, even if you don't have to file an estate tax return at the death of the first to die, you can capture that $11.2 million and save it. Now you may say, well, why is that important? Well, if you have a $20 million estate and you have a trust that says, honey, I love you, give you everything. If you don't port the exemption, how much exemption do you have when second to die dies?
Just 11.2.
Bingo.
So do you have to pay taxes then? If you're porting exemption?
Yeah, if you didn't port that exemption. So if you got $20 million estate and you didn't port the exemption from the first to die, you only got $11 million. But if you ported the exemption from the first to die to the second to die, how much do you have?
22.4.
Exactly. You have 22.
So it all goes directly to the spouse, and then at the end is 22. And
Correct.
you have to, like, demand that, basically.
Right. You have to fill out affirmative election
Okay.
to port the DSUI to the second death.
But then you keep all that money when you put it.
You do. You basically, it's like you're preserving the exemption.
Okay.
So that's what's called portability of election. So we port the DSUI to the second to die, and now we have the first to die exemption plus the second to die, and oftentimes you can then shelter everything from estate taxes at the death of the second to die. Make sense?
So as you said, if you're below the 11.2, then you do not have to fill out a death
706,
estate,
right?
but you still have to file something with the IRS that says, because my spouse's estate was less than 11.2, I am
I'm still,
alerting you that I will be taking his 11.2 exemption
You
and
got
applying it to me.
you got it. So you have to file an estate tax return just to preserve that portability of exemption if you want to port it.
What's the time frame?
15 months. Yep. Now, there has been a private letter ruling and a treasury regulation that if people forget to port the DSUI, the IRS is being really nice and letting people go back and retroactively port it, but why go there? If you want to port it and you're practicing estate planning attorney, you calendar 8 months, 706 extension due in 1 month, you calendar 9 months, 706 extension due because you can extend it for 1 6-month period of time. Then you extend it, and then you calendar 14 months and 15 months, making sure you got that 706 filed so you port in the DSUI. Okay? Now, you may say, well, why is that important? Well, let me tell you why it's really important right now. Because if we go back to $5 million index for inflation,
And you're at 16.
then you're only at 16. So I've told, and I sometimes, so when I explain this to clients, when first to die spouse dies, I say, so here's the deal. If I've got a client that's worth about 15 million and I got, honey, I love you, give you everything, am I porting that exemption? Hell yeah, I'm porting that exemption. And if the client says, I don't want to port the exemption, I go, okay, then sign here. I told you, you decided not to do it. Because when you die and your kids are now paying an extra $4 million of estate taxes and they come and want to sue my ass because they said, well, why didn't you make my mom do the DSUI? I go, here's the letter. I told mom to do the DSUI and she didn't want to do it. She didn't want to spend the $2,000 or $3,000 of legal fees and CPA fees to get this done. Not my fault, right? Because I've had a couple of clients that say, no, I'm not going to port it. I go, okay. Just sign here. I told you to do it. You decided not to do it. I'm not liable. Okay? Because do I think exemptions are going back down to 5 million index for inflation? Oh yeah, absolutely. because remember, it's a sunset provision, it will happen automatically unless Congress takes affirmative action to put it back to the 11.2. And considering that Congress just went Democratic control and the Senate is still Republican control and estate taxes, everybody thinks it's a rich person issue. I think we're going back to 5 million index for inflation in 2025. Okay?
Yeah, another election cycle.
Yeah, but people, we have a real shift in this country politically about money and wealth.
Yeah.
And how people feel that it's not equally distributed, although, I mean, I don't want to get into political discussion because, boy, I can argue that. But I think there's so much of this shift where people feel like there's so much disparity between the uber rich and everybody else that it's very popular to say tax the rich.
Yeah.
Well,
Right?
yeah. Also because in 6 years, 2025, Trump's going to be leaving office.
He's
And
gone.
what are the odds that the Republicans?
Another Republican after his 4-year untempered term will be out.
After 8 years of,
Yeah, no.
I mean, what,
That's exactly my point.
it's low.
I think that the
Oh, yeah.
likelihood
It's
of
going to be
Trump,
complete Democratic, probably.
yeah, I think the likelihood of him getting
House,
reelected
House,
is
Senate,
50-50, but I do think that
If he does, then.
if he gets reelected, I think the Republicans hanging on to the Senate is unlikely. Right? So that's why I think portability of exemption is very important. Okay, if you look at page 977, you see the little pictures of where all these state taxes are owed, right? Washington, Oregon, Minnesota, Illinois, Tennessee, North Carolina, New York, Delaware, Maryland, DC, Rhode Island, Connecticut, Vermont, Maine, and New York, Massachusetts. Very interesting.
So is an inheritance tax like we paid your estate tax, we got our inheritance, and now we're getting taxed again?
Uh-huh. Yep,
That's so it's a triple tax.
Yeah, for real.
exactly.
It's like,
Is the inheritance tax, well,
Depends.
obviously it's the different states, but is it generally as high as like the federal estate?
Oh, no,
Oh.
it's usually lower,
Okay.
but still,
Yeah.
it's ridiculous.
You just pay the state tax.
You just paid income taxes on everything you earned. Now they pay death taxes, and now you pay an inheritance tax?
I mean, it really sucks if you live in New Jersey or.
Well, is the government trying to keep the people
It's-
oppressed and keep them from getting
It's
rich?
absurd. I mean, it's crazy.
You at least
So,
pay one or the other. I mean,
Well, they're
or
trying
neither. I mean,
yeah.
I choose neither, but.
to, we're in
So-
California, so we're good. Right?
Yeah, well, in California, we have no death taxes.
His parents live in California.
We sure
Oh.
tax the heck out of income. So the last thing to remember is when we are doing revocable living trust, right? The standard trust that most people do, the probate avoidance trust. That is what we call a grantor trust. And it is a disregarded trust for tax purposes. So there is no separate entity, there is no separate EIN number, there is no separate tax return. You just report everything on your personal 1040. It's like you own it, right?
Mhm.
That's a grantor trust. Okay, because sometimes people come in and say, oh, I need an EIN number for my revocable trust. I go, no, you don't. It's your social security number. There's no EIN number. Now, I have had people come in with a grantor trust and have an EIN number because their estate planning attorney told them they need an EIN number. I'm like, what in the world are you talking about? That's someone that failed wills and trust class. They told you that.
We used to get them a lot when I worked at the bank.
If there's a death of the first to die spouse and you have a split trust, then that decedent's trust becomes an irrevocable trust and needs an
And it
EIN.
has the EIN.
Correct.
Yeah.
If I die and I have my own single person trust, once I die, my trust becomes irrevocable, right? Then we need an EIN. But while I'm alive, it's my social.
What if it's a joint one? Like
It's a
if
joint trust, it's
your
husband or wife,
husband or wife.
Yeah, it doesn't matter who's social, it's just you're reporting on a joint tax return.
tax return.
Right.
so when you need the EIN?
You need an EIN when it's an irrevocable trust, okay? So once a revocable trust becomes irrevocable, or if it's an irrevocable trust from its inception. Remember when I gave you the Google stock and I set up your individual irrevocable trust? That has an EIN.
You mean like employment identification?
Yeah, it's an EIN number, like an employment
Like a
identification number.
social.
Yeah, it's like a social for an entity, okay? So grantor trust, the grantor social, or the grantor socials. But once the trust becomes irrevocable, that's when you switch into an EIN, okay? And it's no longer at that point, it was a grantor trust when it was established, but now it's an irrevocable trust. Everybody clear? So I have my trust, I die, my trust flips from revocable to irrevocable. I'm alive and I have a stroke and I don't die. Has my trust become irrevocable?
Not unless there's a clause in there that says if you become.
It's become
Incompetent.
irrevocable by virtue of the fact that I'm incompetent, but it's still my social security number because I'm still alive. Okay? Okay, does everybody understand that distinction? You look perplexed, Will.
Yeah, I need to figure this
Well,
out.
just think of it this way.
Yeah,
Here's the best way to think about it. When I'm alive and I am filing my personal 1040 tax return, right? I use my social security number, just like you all. You get your W-2 and you file your taxes and you use your social security number.
And if you're a business, you use an EIN.
If you're a business, you use an EIN.
But
Okay.
why does it matter? I mean, I don't understand, like, okay, because you're saying the trust doesn't have
Well, let me
a
explain.
social security number.
No, let me explain. So while I'm alive, everything's on my social security number. I die on, let's just assume I die November 1st, okay? Now, Vincent's become my trustee. Well, Vincent is going to marshal my assets and put them into his name as trustee of the Julia Bird Trust. But
I
because
don't
I'm,
tax on
right, but because I'm no longer alive, Vincent, and that trust has become irrevocable, there's been a change of status, if you will. Now, Vincent gets an EIN number and he transfers all my stocks and bonds into that EIN number, because if there's future income in that, it shouldn't be reported now on my social security number, because in 2019, I don't have income per se, I'm dead. My income needs to be reported under the trust at that point. So now there's a tax return for the trust,
That makes sense.
okay? Holy shit,
It's a big break.
they must have something leaking over
It's a guy.
it. Yeah, it is husband.
It's a person on the roof.
Why is he going on the roof?
It's a good question.
Maybe they do.
Oh, no, but you're saying, because there's something leaking. That's what
Yeah,
you're
maybe
saying.
it's
Oh.
leaking or something.
Okay. No, that wasn't the sound of raindrops.
Okay, so believe it or not, guys, we're done. Any questions on wealth transfer? I've given you the highlights. There's a lot more I could teach a class on wealth transfer for a whole semester.
I was saying, I'm sure there's an
It's
entire
not
semester
transfer.
of tax law that is
Well, that's
just.
why we go to CE class, and like I go to one CE class usually, and it's 24 hours. It's in October, I was in Hawaii this year, but it's pretty much all just tax.
Okay.
You
We
get
don't get a tax.
You done
class.
with 3 days and you just go, oh my
I don't
god,
want tax.
my head hurts, you know.
That can be another one that you like that I hate.
Yeah.
We don't teach a
A
taxation
tax
class.
class.
Yeah, but when I went to law school, we had tax class. I was good at that.
I would be
I need
so
to partner with
confused.
Victor.
What?
So, I need to partner up with Victor, because everything that he likes to do, I don't like to do. And everything that I like to do, he doesn't really like to do.
Okay, so next week, we're gonna do review. Come prepared with your questions. We'll kind of go through the highlights. Nicole and I were working on the final exam questions. Remember, you're gonna have 2 essays. Okay, you know you're gonna have a trust question, right?
Yeah.
Because we didn't
Assuming
test,
A trust.
we did not test trust on the midterm, right? So you know there's the trust question. Okay,
So, say formatting, do we just pretty much follow the Barbary outlines for like a
I just printed out all those, well, when I don't have his family, but from the ones that you gave us a couple years ago.
Yeah.
and I think that,
Binders.
sheet that Will's looking at, I think
I'll add to my
if you
binder.
were to look at that now, you would realize that we have literally covered every topic on that sheet in the past 14 weeks.
Went by fast.
14? It's such an
Yeah, it is
interesting
14
topic,
weeks.
don't you think?
Wills and trusts?
Yes.
It's more interesting than the rest, but it's super confusing.
Yeah,
But it's more interesting than so many other classes,
that's true.
don't you think?
Yeah.
Well, because families are crazy. And
Of
that's
course
why
they
I
are.
want to do family law, because it's something new.
But you'll have a lot of overlay with the
Oh,
estates
yeah.
and trust issues with family law too. Because how many people have trusts and wills and reciprocal wills and joint trusts, and then you have to start worrying about what does the trust say and revoking them and it's a lot of overlay. Yeah, that's why it's important. I think the most important thing when you're practicing law is to know when to spot the issue. Doesn't mean you have to know the answer, you just have to say, you know what, you got an issue here, you better go see so-and-so, right? And that's the art of being a good lawyer. You don't have to have all the answers. I mean, I remember Nicole said, she goes, I remember one time we were meeting with a client and you just came around and said, I don't know the answer, but I'll find out. She goes, I always just thought like lawyers knew everything, and it was so surprising to me that you would just say, I don't know, but I'll find out for you, right? Because why bullshit people?
Yeah.
I mean, I don't know everything. I know this. But even today, I had a client that called me. She has a custodial account she has to set up because her son died, and the Nevada court where he died ordered that custodial accounts be established in California. Because they were going to do ongoing trusts. I said, oh my gosh, this is only like $100,000. This is ridiculous. So I said, why don't you have the Nevada attorney do a custodial account? So we got the Nevada court to issue that. And so the financial advisor said, what's my investment standard on the custodial account? Do we have any restrictions? And I thought, that's a really good question. I'm going to find out. So I looked in the probate code, I went into the custodial section, which is like the 3900s, and I found under 3912B, it said the standard for investment is the prudent investor. I'm like, perfect. So that means it's not limited, it's not just T-bills or something like that, it's prudent investment standard. So I was able to say, here you go, 3912B, prudent investments, Satish, who's her investment advisor, I said he'll understand exactly what that means. He considers the girl's age when they're going to be entitled to this money, which is at the age of 18. And the girls are like 6 and 7. So he'll invest it for 11 years, and 12 years respectively, using the prudent investor. But see, I didn't know the answer, but I found it, right? I was very proud of myself. I'm like, oh, there's the answer. I knew there'd be an answer in the code. And as long as you know what prudent investor means, then you know what the answer is, right? Because you guys know prudent investor rule now, right?
Yeah, you take it to the casino, put it on red. So.
There we go. Red 16, call it a day. Not exactly prudent investor.
Put it on Bitcoin.
Yeah. Okay, very good, you guys. Okay, see you next week for a review, and then that'll be it. And thank you for teaching me how to use the erase board.
It goes further than that. Like you could save everything you write. It says.
You know what? I actually should get this for explaining to clients things.
And
you can just email it.
You can email them right afterwards, all your handwritten
Do
notes.
you know how much this thing costs?
Sure they do.
think we got an email.
Just ask John. I mean, you have the right answer,
I want to say it was around
It's
10,000.
No.
No way.
Really?
I don't think John spent it then.
I
can build one for like 2.
well, it's got a computer in the back of it
No, my
too.
computer's only worth like $1,000 at most. If you buy it.
At most.
'Cause it's not like a.
It's not a super
It
computer.
You
doesn't-
know what?
it doesn't
I
do-
bet you too with technology, these things have come down in price
Well, it's not like
dramatically.
you can put like a CD in it, like run a like you don't have a hard drive really. I mean, they do a little
Oh,
bit,
it's-
but not really.
I'm sure it's web-based.
Well, it's just a computer.
But like, it's like you want like a gaming system on it.
All it
How much
does
are
is plug
they? $2
in.
grand? Probably like 2.
2
The
grand, I'd buy that.
The standard is as low as 4,000.
Display 10? Are you looking at
Yeah, at their web on their shop website.
Okay, see, that makes sense.
The standard is $4,000. If you get the suite, which theirs looks like the D5, which is $43.94, or as low as.
Yeah, see, that makes sense because I figured the parts were like 2K. They're probably making like $2 grand each.
Wow.
Yeah, because it's a 4K display, and then it has like, I know it has a Windows 10 computer in it, and it's touch screen, and
It's pretty nifty.
That's really cool, yeah.
Yeah, but I was like, no, wait, it's
I might have to think about
Well,
this.
I think that's what Alana tried to,
trying to rent an office.
well, no, tried to fundraise for.
Honestly.
Gentlemen, I'll see you next week then.
Thanks.
Okay, bye.
You guys will see you tomorrow.
I guess it is cool. I never really
Don't
thought
forget to dress up.
Yeah.
Yeah, it's a